Hello, everyone. Good evening, and welcome to our members briefing call on the Digital Personal Data Protection Bill 2022, or as we'll be calling it for the next 30 to 45 minutes, DPDPB. Right now, some of you may be familiar with the format of these briefing calls, but let me just quickly go through that again. We'll be doing this in two parts. First, there'll be a briefing on the bill by my excellent colleagues Anushka, Jain, and Tejasi, Panjiar. This is the part that we'll be live streaming on YouTube and Twitter. After this, we'll go into a members only conversation. And at this point, I should point out that if you want to support our work and if you do want to be a part of these conversations outside of the live stream, then please do donate to IFF. And with that, we can get started. Can we move to the next slide, please? Okay, great. So what you're seeing here is a timeline, right, of India's journey to a privacy legislation, which, going back to 2011, which included an early draft, and along the way we've had things like important events like the constitution of the Sri Krishna Committee, the landmark Puttaswamy judgment, which by the way IFF, as many of you know, commemorates every year through Privacy Supreme. We've had three versions of a data protection bill, which we had compared in a draft that we had put out, and as all of you are familiar, in August there was a withdrawal, right? But I want to talk less about the timeline and a little bit more about the broader state of things in India, especially with to do with the technology policy, right? Now we were disappointed when the bill was withdrawn in August 2022. But we did note at the time, with some optimism that look, if the government chooses, there is years and years worth of feedback that it has at its disposal to improve any future versions of a bill that comes out. Now, disappointingly, many of the concerns that civil society raised, as we'll talk about today, have don't seem to have been taken adequately into account, right? Another thing to consider in just keeping the broader frame and the larger context in mind is that we are at a critical stage right now. We've recently had consultation on the telecom bill. We're sitting right now in the open consultation period for the data protection bill, and we have the potential for another consultation coming up on what's being called the Digital India Act, but really it should be Digital India Bill, and I don't know why people aren't pointing that out. Right now, some of these have been referenced as quote unquote comprehensive legal framework, right? But we don't really have an upfront articulation of what the elements are exactly, how they'll work together, what timelines are being considered. This is something that we've recently written to METI about to ask for greater clarity, but it doesn't exist today, right? And a trend that we've noticed with the telecom bill consultation and this the one that we have right now, and we're talking about it, is also there seems to be a greater trend towards more centralization of power and greater discretion in the hands of the union government itself, while strangely enough then going and imposing duties and or penalties on average everyday citizen, right? And this is something that's a matter of great concern for us. And let's be clear, it is an important task. It is not an easy task, right? And which is why we've been constantly asking for open, transparent consultation processes, so that these legislations can head in the right direction. And what we've seen is that while now people are making the right noises about having open consultation processes, they don't seem to be necessarily being following through in the actual spirit of it, right? For example, even with this consultation, it's being said, the call for consultation itself said that the responses will not be put out in public, right? Which I think is a huge loss for us, because if they were put out in public and we had the opportunity to provide counter comments, that would have improved the process. It would also give us the opportunity to understand how various stakeholders approach our privacy, right, and data protection in general. But as of now, it seems that we will not have that. We will have that that opportunity, right? So with that, let me just turn it over. So actually, just a final point on that. is that despite what I said, it is extremely important to still engage with the consultation process, to ensure that the concerns that we have are raised, and and ensure that any suboptimal legislation is not being consultation washed, right? If I can make up a term. So with that, I'm going to turn it over now to Anushka and Tejasi to go through the bill itself.
Thanks, Prateek. Hello, everyone. Thank you so much for deciding to spend your Friday evening with us. We hope that this call is of value to you. The Digital Personal Data Protection Bill 2022 has been years in the making, like Prateek has just said, and it's very important that we deconstruct each and every clause to understand what it says. So we're going to start going through the clauses as they appear in the bill. Just so that anybody at home who's going through the bill with us can go through it easily. I'm going to start with clause 4, which describes what the scope of the act is going to be. The clause says that it will apply to processing of digital personal data. And now they have defined digital personal data, not defined per se, but they have restricted digital personal data to personal data which is collected from data principals online, and personal data which is collected offline but then digitized. Here, it's very interesting to see this categorization being made, because it then excludes a lot of other types of data. The clause itself says that it will not apply to non-automated processing. Here, automated has been defined in the bill as any digital process capable of operating automatically in response to instructions given or otherwise for the purpose of processing data. It says that it will not apply to offline personal data, and records older than 100 years will also not come under the scope of the bill. Here, first of all, because there is no consultation paper that was provided before the bill was released, we don't know why this has been done, what was the thinking behind this. We also don't know if there are other legislations which are in the process which will regulate what is left out of this bill. I'm not going to go into a lot of detail because we have a lot of clauses to go through. So I'm just going to say that it's worrisome that this has been done, that this has been restricted to digital personal data, and we don't know why this has been done. Can you go to the next slide, please? Yes. So the next clause that we're going to discuss is notice. This clause is quite long, actually, but we're going to discuss just subclause 1, which is that data fiduciary shall give to the data principal an itemized notice in clear and plain language, which will contain the description of the personal data which is sought to be collected and the purpose for which they're going to process the personal data for. Now, this is good in the sense that these things need to be made known to the data principal. However, there are certain things that also need to be made known to the data principal in the notice, which this clause does not contain, which then attracts our worry. This includes, can you go back, please? Yeah. This includes the fact that the data fiduciaries now don't have to inform the data principals if they are going to share the data with any third party. They only have to give this information if the data principal asks for it themselves, and they don't have to include this in the notice. Additionally, they don't have to tell them the duration for which the data will be stored, if it will be transferred to other countries. Now here, why I'm saying duration for which data is to be stored is because even though there is a storage limitation contained elsewhere in the bill, there are exemptions to the storage limitation that have been provided to state agencies. So here, state agencies may collect your data and you don't know when it's going to be deleted or till when they're going to store it. Now here again, my colleague is going to discuss the removal of the data localization requirement that was there in the previous bill, but is now not in this one. However, in the notice, they have not asked the data fiduciary to include the fact that they may transfer transfer the data of the data principal to other countries, which is something that any data principal who wants to make an informed choice should be able to know. Can you go to the next slide, please? Yes. Now, clause 7 talks about consent. It says that consent of the data principal means freely given, specific, unambiguous, and informed. However, like I just said, because the notice requirements themselves are not sufficient, it's very difficult for the consent by the data principal to be informed and unambiguous. However, what is also worrisome is the next clause, which says consent may be assumed or deemed under clause 8 for certain situations, which includes for taking measures to ensure safety or services to any individual during disaster, breakdown of public order, purposes related to employment or in public interest. Now, these are vague and wide terms, and for these purposes, if consent is going to be assumed, this may mean that there could be n number of possibilities in which any data fiduciary may think that they can assume or they can deem the consent of the data principal. And here, in this situation, it might become difficult for the data principal to first of all know that this has happened and then to approach the data protection board under the bill to seek redressal. Here again, clause 8.6, 8.7, and 8.8 also states that consent of the data principal can be assumed for purposes related to employment as well. So here again, the question, one of the clauses states that 8.7 states that it can be done for employment. So here again, the question of workplace surveillance arises. We had done a brief on workplace surveillance when we were assessing the 2019 bill. However, this is something that definitely needs more discussion. Can you go to the next slide, please? Clause 9 talks about general obligations of the data fiduciary, which is quite simple. So I'm just going to run through it. The data fiduciaries have to comply with that. They have to keep the data accurate and complete, implement appropriate technical measures to ensure adherence with the provisions of the bill, take reasonable security safeguards to prevent personal data breach. And personal data breach has been defined in the definition clause, which is a good thing. It has to notify the board, which is the data protection board under the bill, and each affected data principal in case of a breach, which is also a good thing. It has to cease the retention of personal data when the purpose for which the data was collected is no longer being served by its retention, and the retention is no longer necessary for legal or business purposes. This is the subclause which basically puts in place the purpose limitation principle of the GDPR in this Indian bill, which is a good thing. However, like I said, there are some state agencies which may be exempted from the data retention clause, which is worrisome. They have to publish the contact information of the data protection officer. It's a good thing. And they have to have in place a procedure for effective procedure and effective mechanism for redressing the grievances of the data principals, which is also a good thing. Can you go to the next slide, please? Now here, there are some additional obligations that would be placed on significant data fiduciaries. Significant data fiduciaries will be notified by the government at a later stage on the basis of some relevant factors, which include the factors listed here, which is volume and sensitivity of personal data, risk of harm to the data principal, potential impact on sovereignty and integrity of India, risk to electoral democracy, security of the state, public order, and such other factors as it may consider necessary. Again, this is a very open-ended clause, and it leaves a lot, it gives a lot of leeway to the government to notify any data fiduciary as a significant data fiduciary and apply excessive obligations on them. The additional obligations on a significant data fiduciary are that they have to appoint a data protection officer, they have to appoint an independent data auditor, they have to undertake measures including data protection impact assessment and periodic audit, so that they are complying with the objectives of the bill. Can you go to the next slide, please? Here, I would like to ask my colleague Tejasi to step in, because she will be discussing these clauses.
Thank you, Anushka. And once again, good evening to everyone who's joined us today. So we will now discuss the clause which imposes additional obligations on the data fiduciary with respect to processing of children's personal data. So I think we can comfortably say that clause 10 imposes significant hurdles in the processing of children's personal data. Clause 10, subclause 1, imposes an obligation on the data fiduciary to obtain verifiable parental consent before processing any data. Clause 10.2 prohibits processing of personal data that is likely to cause harm to a child. Clause 10.3 prohibits them from undertaking tracking or behavioral monitoring of children or targeted advertising directed at children. While these provisions are welcome, Clause 10.4 seriously undermines things by making provisions for exempting data fiduciaries from application of Clause 10.1 and 3. Again, the bill does not mention the criteria or the standard based on which the union government would grant such an exemption. And you probably guessed it right. The phrasing used in this case is as may be prescribed. Moving on, we will now discuss. So before we go into this, just largely what the bill actually intends to do and whose rights it aims to protect is a question that I believe remains largely unanswered throughout the bill. For instance, as you can see on the slide, the bill not only gives certain rights to the data principals, which is great, but it also imposes duties on them. So we'll start on the positive note first. The DPDP strengthens user rights by giving the data principals right to information about personal data, that is clause 12, right to correction and erasure, clause 13, the right of grievance redressal, clause 14, and the right to nominate, clause 15. Also, the provision in the previous bill, which allowed data fiduciaries to reject requests for correction, completion, updation, or erasure of personal data if they disagree with such request, has now been removed. So this was on a positive note. On a not so positive note, the right to make requests for data portability and the right to be forgotten, which was present in the earlier iteration of the bill, has now been removed. Now moving on to the duties imposed on the data principal. Under clause 16, these duties include the duty to comply with the provision of all applicable laws, duty to not register a false or frivolous grievance or complaint, duty to not furnish any false particulars or suppress any material information or impersonate another person, and the duty to furnish only such information as is verifiably authentic. What is clear is that the move to introduce duties on data principals is a significant departure from earlier iterations. We will be observing the duties clause more clearly later on in the presentation when we discuss the associated penalties that the BEAC seeks to impose on data principals in case of non-compliance with their duties. So stay tuned for that. But for now, moving on to clause 17, that pertains to transfer of personal data outside India. First things first, the requirement of data localization has been done away with in this bill. What it does appear to replace it with is an allowist approach, which is basically that the data fiduciary can only transfer personal data to such countries as the union government may prescribe. So the implication here is that the transfer of data to any country that the union government doesn't prescribe is prohibited. Clause 17 does not prescribe any standards or criteria based on which the union government should decide which countries to allow data transfers to. Now, what essentially happens here is that it enables arbitrary exercise of power where countries may or may not be selected based on considerations other than protection of personal data of Indians, which should ideally have been the case. This is also in contrast with Articles 44 to 50 of the General Data Protection Regime, which permits transfer of personal data of Europeans only to such countries which provide minimum level of protection to such data. Over to you, Anushka.
Thanks, Tejasi. Now we're going to discuss clause 18, which is the exemptions clause. If anybody of you has followed the journey of data protection in India, since the 2019 bill came into conversation, a lot of the criticism that that bill faced was because of the exemptions that it gave in clauses 35, 36, 37, 38, 39. Now, in this bill, while there is only one clause which specifically relates to exemptions, it's very disappointing to see that the exemptions that were there in the previous versions, which caused a lot of worry to several stakeholders, have been retained in this one as well. And in one clause, they have actually been subclause, they have actually been expanded. So here, first of all, I'm going to talk about 18.1, which is that in these situations, certain sections or certain clauses of the bill will not apply. So, for example, for processing of personal data when it's necessary to enforce any legal right or claim, processing of personal data for for any for the performance of any judicial or quasi-judicial order, processing of personal data in the interest of prevention, direction, investigation, prosecution of any offense, and personal data of data principles, which is not within the territory of India. Now here, what will they be exempted from? In these situations, what will they be exempted from? So they will be exempted from Chapter 2, which relates to obligations of data fiduciary that we've discussed already. However, one exception to the exemption is that subsection 4 of section 9, which is that every data fiduciary and data processor shall protect personal data and take reasonable security safeguards. They still have to do that. They're not exempted from that. They're exempted from Chapter 3, which relates to rights and duties of data principles. So that means that all the rights that the data principles have, if these situations are there, they cannot exercise these rights. And clause 17, which relates to transfer of personal data outside India. Can you go to the next slide, please? Yes. So now 18.2 is the one which is the most important, in my opinion. This one is almost entirely replicating what clause 35 of the Data Protection Bill 2021 was doing, which is that it will allow the central government to exempt from the applications of the entire act by notification any instrumentality of the state, which is basically any state agency or state body, in the interests of sovereignty, integrity, security of the state, friendly relations with foreign states, maintenance of public order, and for preventing incitement to any cognizable offense. Here, what is extremely important to note is that we already have a very weak surveillance architecture in the country. The existing surveillance architecture in the country is Section 5(2) of the Telegraph Act, which will now be replaced by the Telecom Bill, which essentially replicates what the Telegraph Act was saying. So there's literally no difference, except for it widens on whom the surveillance can be done. And the IT Act, Section 69. Now, both of these provisions have already been criticized a lot because they concentrate a lot of power with the executive and they don't have any sufficient judicial oversight or any oversight, which would ensure that excessive surveillance is not taking place. However, what we were wishing for is that once the data protection law comes, there will be some regulation, because data protection at the end essentially is to protect the right to privacy and to protect the personal data of citizens. However, by putting in place these exemptions, the government has essentially allowed itself to continue the power that it is already enjoying, which is excessive surveillance powers. Here, it's also important to note that clause 18.4 states that state agencies will be exempted from the general obligations of data fiduciaries to limit retention of data. That means that they can collect the data and keep it with themselves for however long they want. And this is something that we also saw in the Criminal Procedure Identification Act, wherein it states that you can collect biometric data and keep it for 75 years, which is just arbitrary. Can you go to the next slide, please? 18.3 is the one that is new, and it's also the one that is also being discussed a lot because it's new. This exemption states that the central government can now, by notification, exempt certain data fiduciaries or class of data fiduciaries from the application of Section 6, Section 9, Section 10, 11, 12 of the Act. And here, what the previous bill was doing was that it was giving exemptions to small data fiduciaries. However, by changing the language to certain data fiduciaries and keeping the power to notify them at a later date, the government has weakened the language from the previous iteration of the bill. Now here it's very essential to question the intention of the government in drafting this provision, because if it is only for small data fiduciaries, then that language already existed previously in the previous iteration. Then why was this language diluted if it's only going to apply for small data fiduciaries? So we are of the opinion that certain data fiduciaries may include any data fiduciary that the government may want. And essentially what this will allow is that private actors which are collecting your personal data would be exempt from the provisions that are listed here. And it would again allow for excessive surveillance, and it would allow for the violation of the right to privacy of citizens. Can you go to the next slide, please? Yes, thank you. Now we're going to talk about the Data Protection Board. In the 2021 bill, it was the Data Protection Authority. Now it's Data Protection Board. I'm not sure why the name has been changed. So what does this clause do? The clause says that a data protection board has to be put in place, which will be the tribunal where any data principal which has any issue arising out of how their personal data is being processed can go to seek redressal. However, one of the most important things for the data protection board was that it is independent. However, under clause 19.2, the strength and composition of the board, the process of selection, the terms and conditions of appointment and service, and the removal of its chairperson and other members, all of this will be prescribed at a later stage by the union government. So basically, the power to do all this and the power to decide how all of this will be done will be prescribed by the union government at a later stage, which means that, first of all, we cannot effectively analyze this clause or this data protection board and its effectiveness because we don't know how it's going to be formed. So again, this is also an issue with the consultation process of the entire bill. The second clause, which also questions the independence of the Data Protection Board, is 19.3, which says that the chief executive of the board will be appointed by the union government. Now, what this does is that it was very essential that the Data Protection Board be independent, because the Data Protection Board at the end of the day has to protect the interests of the data principles. However, if it's being appointed by the government, it is very likely that it will instead replicate government interests and put government interests before user interests, which would ultimately again defeat the purpose of the bill and would cause harm to the data principles. Can you go to the next slide, please? Now, another power of, one of the powers of the Data Protection Board is the power to review and appeal. Under that, under clause 22, subclause 3, the bill restricts the jurisdiction of civil courts and provides exclusive jurisdiction to the Data Protection Board over all disputes arising out of the provisions of the bill, thereby creating a specialized tribunal, which is the Data Protection Board. Now here, this raises concerns because of two reasons. First of all, it undermines the stature of the judiciary and offers more control back to the executive, because like I said, the Data Protection Board, because of the way that it is going to be formed, may provide more importance to government or executive interests than user interests. And the second reason is that India's experience with tribunals has been disappointed. The example that I've stated here is the Central Information Commission. Anybody who's worked with the RTI Act knows that if you file a second appeal with the CIC, it takes at least 2 years before the CIC hears your appeal, because that is the level of pendency that Central Information Commission suffers from. So in such a situation, just imagine what will happen with the Data Protection Board, wherein your personal data is being processed and you have a concern, but you file that concern and it takes 2 years for them to take that up. Just imagine the harm that will occur to you while that 2-year period, this is just an example, but while that 2-year period goes on. The next slide, my colleague Tejasi will talk about. Tejasi.
Thank you, Anushka. Okay, so I promised that we will look at the duties and associated penalties more deeply, and the time to do that has finally come. Clause 25, which pertains to the provision of imposing financial penalties, empowers the Data Protection Board to determine and inquire the non-compliance of a person. It also gives the person being inquired, whether it is a data fiduciary, processor, or data principal, a reasonable opportunity of being heard, which does provide some relief. Now, the penalty which may be imposed by the board after concluding the inquiry will be as specified in Schedule 1. So let's take a look at Schedule 1, which is the image on the right. What I want all of you to focus on is the highlighted part, which says that the penalty that may be imposed on a data principal in case of non-compliance with Clause 16 may not exceed 1,000 rupees. So a quick reminder, Clause 16 pertains to the duties imposed on the data principal. So while for instance, and this is an issue, right? So let's take an example. While the efforts to limit false and frivolous grievances as introduced in Clause 16, subclause 2 is notable, the associated penalty for not complying with this duty will almost certainly disincentivize genuine grievances. Another important reminder, both these provisions, that is the imposition of duties and penalties on the data principal, did not exist in earlier iterations of this bill. This introduction is extremely concerning, since a legislation that supposedly aims to protect the rights of individuals is instead imposing penalties on them. Moving forward, we will discuss the clause pertaining to the amendments. So Clause 30 amends certain sections under the Information Technology Act. Specifically, Clause 30, subclause 1A is worth noting as it aims to omit Section 43A of the IT Act. Now, what does Section 43A say? Section 43A provides damages to affected users in case of a data breach. By taking away the provision to award damages to affected persons, and by introducing Clause 25, which contemplates monetary fines even on the data principal, no direct relief will be provided to the directly affected person, That is the individual who has suffered the loss of their personal and sensitive data. Now, we must know that on one hand, the bill makes a positive alteration by introducing provisions such as mandating that the data principal be notified in case of a breach to the personal data, which is a great step. However, on the other hand, the state makes no provision for compensating the data principal in case of any such occurrence, marking an injudicious deviation from the earlier iterations of the bill. The government also seeks to amend Section 81J of the RDI Act, which relates to personal information. By doing this, they are further making it easier for the public information officers to misuse this section, which they were already widely known to do before. So if you see the text in red, that is what the bill seeks to delete in 81J, and the text in red is what currently remains or will remain once this bill becomes an act. So basically what is happening is that the qualifiers based on which the public information officers could withhold information, that is, that the information must have no relation to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, has now been removed. Earlier, this was conditional. Now, this has just become the proposed amendment would allow public information officers to deny public requests for information on the very broad ground that is personal information. And a side note here, personal information has not been defined in the Right to Information Act. It is worth noting that while public interest, that is the qualifying exemption to withhold information, will be omitted, Section 8(2) in the RTI Act still allows a public authority to allow access to information if public interest in disclosure outweighs the harm to the protected interests. Now, the clause 30, specifically clause 30, subclause 2B, omits the proviso to section 18J in the RTI Act. The proviso states that the information which cannot be denied to the parliament or a state legislature shall not be denied to a person. Now, this was another exemption that was introduced in the RTI Act to ensure that information is not withheld arbitrarily or without sufficient grounds. However, unfortunately, by attempting to omit this proviso, it weakens the RTI Act because the grounds on which information can and cannot be denied to the parliament or state legislature are already very well defined, and they have been in existence for a very long time. Overall, if I would sum up this amendment clause, it completely removes all earlier existing qualifiers or conditional exemptions in the RTI Act and brings further arbitrariness in the release of information sought. Back to you, Anushka.
Thanks, Tejasi. Now, this last thing that we're going to talk about is an overall concern, not a clause-specific concern. The bill only has 30 clauses, which some people think is a good thing. Some people think is not a good thing. Jury is still out. What we've noticed, however, is that to make the bill small and concise, they have done something which is very interesting. And also, because there's a lot of worry. I feel like I'm saying that a lot, but it does. So the bill mentions the phrase as may be prescribed 18 times. And what this does is that a lot of the things in the bill have been left for the union government to prescribe at a later stage. What this means is that this bill, which is open to public consultation right now, which is going to be at least debated in the parliament, it does not contain a lot of the actual meat of the act. The things that have been left to be prescribed later include the technical, operational, financial, and other conditions for the registration of consent managers under clause 7. Any fair and reasonable purposes for which a data principal will be deemed to have given consent for the processing of her personal data, which is one of the most worrying subclauses. The processing of personal data that is likely to cause harm to a child. The strength and composition of the Data Protection Board, process and selection and terms of appointment, removal of chairperson and other members, like I've said previously. and the terms and conditions for the appointment and service of other officers of the Data Protection Board. So this, by saying that it will be prescribed at a later stage, this gives a lot of power to the executive and takes away power from us and from the parliament to decide how this data protection bill will regulate the processing of personal data. So this is something that they've done, and they've said that they've reduced the language and the length of the bill to make it easier to understand. However, if this is the cost of the bill being easier to understand, then I don't think it's worth it. Now we're at an end for the discussion. What we're going to do now is we're going to end the live stream and take questions from the IFF community, which is IFF's members. If you want to be able to do that, you need to become an IFF member. If you think the work that we do is of value, please consider becoming an IFF member today. Back to you, Prateek.
Thanks, Anushka.